Mr. Young, I'm a little confused. You referred to a department that doesn't exist. What's the name of the department that you're going to work for?
Sir, the name of the department is the Department of Defense.
Correct. Thank you. I appreciate that, and I think you must have slipped before in using that other name that has no legal basis. Mr. Young, you were the general counsel during the deployment of the troops of the National Guard to Los Angeles. What was the legal basis of that utilization of the National Guard?
Sir, the legal basis for that deployment to the National Guard is the President's Article II authority to protect federal functions and property, as well as the President's statutory authority under 10 U.S.C. 12406, sir.
And should there be a factual predicate for such a deployment, such a use of military force? And if so, who decides that the factual predicate has been met?
Well, sir, I would say that the statute is what the statute is, and it's written the way that it's written. That statute's been in existence and been utilized going back to the first president of the United States, George Washington, who mustered 19,000 National Guard personnel to march to Pennsylvania to suppress what was then considered the Whiskey Rebellion, where 500 people were tar and feathering tax collectors. And so the first president of the United States, as he looked at those set of circumstances, thought that the assault on the imposition of federal law and the execution of federal law was sufficient to muster thousands of National Guard personnel from all over the United States.
Is there any review of the president's decision in a case such as this to deploy troops? You cite the statutory basis. Is there any appropriate review of that decision, or is it a completely unilateral, unreviewable decision of the president?
Sir, I would say that matters in litigation before the Ninth Circuit Court of Appeals. The Ninth Circuit has issued a determination regarding the standard under which it would look at the president's factual determinations and gives significant deference based off of prior Supreme Court deference to the president in being able to ensure the execution of federal functions, the protection of federal property, and the protection of federal personnel as they're executing their duties.
Yesterday, Mr. Miller, counsel to the president, stated that the judge who ruled the deployment to Portland illegal and unconstitutional was a, quote, insurrectionist. Do you believe that a federal judge interpreting federal law as applied to a particular set of facts should be or could be declared an insurrectionist? That was the term he used.
Senator, I would say that a federal judge interpreting federal law as it relates to the execution of an Article II authority is exactly what our Constitution was founded on, and that's what we expect.
I agree with that, and I hope you'll convey that sound opinion to Mr. Miller. Turning to the recent strikes in the Caribbean, and I realize you're nominee to the Army, but you've been involved in these legal decisions. What's the legal justification for a kinetic strike against civilians in international waters?
Sir, the president, acting under his Article II authority, consistent with the powers that the Constitution has given him, has looked at the facts and circumstances regarding these drug cartels. The president considers these drug cartels to be non-state armed groups, which is what the president has designated them. He's designated them as terrorist organizations. He's looked at the facts and circumstances surrounding the manner in which the provision of narcotics and illicit narcotics have killed more people in the United States over the last 4 years than all of our conflicts
in this
century
Mr. Young, doesn't
combined.
the Constitution specifically delegate the power to declare war as opposed to be the commander-in-chief during a war to the Congress? And historically, we haven't been very good about declaring wars, but we at least have done authorizations of use of military force. Has there been such an authorization or any authorization by Congress whatsoever in this particular situation?
Senator, there has not been an authorization to my knowledge. I would say that the nature, scope, and duration of these activities do not rise to the level of war in the constitutional sense, and that the manner in which the president has authorized these strikes is consistent with both domestic and international law.
Does it raise any concerns with you that the president seems, you're asserting that the president has the power unilaterally to decide who's an enemy, to decide unilaterally that they can be killed without reference to any authority of Congress or any other restraint? If the president can designate somebody as an enemy combatant and then take that action, where does that stop?
Senator, that's a good question. I think those questions have been around since the beginning of drone warfare. I know in the Obama administration there were over 570 strikes that killed 3,700 people, many of whom were U.S. citizens abroad. And there were many questions
I'm out
that
of
were
time, but
presented to the
I believe
president.
that was subject to an authorization by the Congress, the 2001 AUMF. Thank you, Mr. Chairman, for the.
This exchange between Senator Angus King and Trump's nominee reveals something far bigger than a slip of the tongue. When Mr. Young referred to the Department of War, a term that hasn't existed officially since 1949, it wasn't just a language error. It exposed a mindset, a worldview, one that seems to see America's armed forces not as a tool of defense and stability, but as a blunt instrument of force and unilateral power. This isn't just about semantics. The Department of Defense replaced the Department of War for a reason, to signal a shift in how the United States views its military role in the world. That change reflected lessons learned from 2 world wars, from the rise of modern diplomacy, and from the dangers of viewing war as the default solution. When someone seeking high office casually reverts to the old language, it can reveal how they see power and how they might use it. But what came next in this hearing was even more revealing. Mr. Young acknowledged that recent deployments of the National Guard, including to places like Los Angeles and Portland, rely on broad presidential powers, powers that historically have been shielded from meaningful review. He leaned on precedents dating back to George Washington, invoking the Whiskey Rebellion as justification for modern troop deployments. But that example comes from a time when the United States was a young, fragile republic, not a global superpower with the world's largest military. And crucially, our understanding of constitutional limits and checks on executive power has evolved since then. Senator King's line of questioning zeroed in on something fundamental: whether these kinds of deployments are effectively unreviewable, whether they are subject to any meaningful checks from Congress or the courts. The answer, stripped of its legalistic language, was essentially not really. That's deeply troubling in a constitutional democracy built on checks and balances. A president with the power to deploy military force at home with little oversight is a president with the power to silence dissent, blur the line between civil order and militarization, and bypass democratic accountability. And then there's the most alarming part: the justification for lethal strikes against what were described as non-state armed groups in the Caribbean. No congressional authorization, no formal declaration of war, just the president acting under Article 2 authority. This is the very scenario that civil liberties advocates have warned about for years, where the executive branch unilaterally decides who is an enemy, where they are, and whether they live or die. This isn't just a Trump issue, it's a structural problem that has persisted across multiple administrations, including Obama's. But what makes this exchange especially significant is how casually that power was described, as though deciding to launch kinetic strikes in international waters is just another day at the office. Senator King pushed on the core constitutional question: where does this stop? If a president can name anyone an enemy combatant and order their killing without congressional oversight, the entire balance of war powers collapses. The framers of the Constitution placed war-making powers with Congress for a reason: to prevent precisely this kind of unilateral, unchecked authority. Over the years, Congress has ceded more and more of that power to the executive, often for the sake of political convenience. What we're seeing now is the consequence: presidents from both parties exercising sweeping war powers with minimal restraint. This hearing forces us to confront uncomfortable truths. We've normalized endless war. We've allowed military force to be used without public debate or congressional approval. And we've blurred the line between external threats and domestic dissent. When an administration labels a federal judge an insurrectionist for ruling against its military deployment, it crosses from hardline governance into outright hostility toward democratic institutions. This moment should be a wake-up call for Congress to reclaim its constitutional role in matters of war and peace, to reassert civilian oversight, and to stop enabling the slow erosion of democratic checks on power. This isn't about left or right. It's about whether America remains a democracy where no single person wields the power of war unchallenged. If we want a future where power is accountable, where military action is a last resort rather than a reflex, then Congress and the public must act. Ask questions, demand oversight, refuse to accept unilateral authority as the new normal. Because history has shown us that when the language of war returns, the reality of war is never far behind. Call your representatives. Pay attention to hearings like these. They are not procedural footnotes. They are warnings.